Hello, everybody. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all for participating in today's program, the community conversation called Elections, Notices, Ballots, and Legal Requirements. It's a big and important topic for us in the HOA world. ECHO is a 50-year-old statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on your screen. In addition, slides were sent to registered attendees beforehand. Please take a moment to review our housekeeping items. Today, we have a large audience of HOA board members. We will do our best to answer your questions, but we may run out of time, so we'll do our best. Please use the Q&A feature, that is the Q&A feature, to ask your questions. Once there, use the upvote feature, that is the thumbs up, it's an icon, to vote for your favorite questions. We will answer the most popular questions first. And we have probably 150 or so people here. We had over 217 people registered. We ask that you keep your questions general in nature and short. Questions about specific situations are better asked of your attorney, the one serving your association, or another appropriate industry professional familiar with your situation. During the presentation, we will respond in writing to some questions during the presentation, and all other questions will be answered during the Q&A session at the end of the presentation, those at least that we can get to. The chat icon is to be used to report technical issues and to communicate directly with other participants in the webinar. We do not monitor the chat features for questions. Let me now direct your attention to your monitor, where you will find our disclaimer. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. This event, as well as all of our events, is made possible by the generous support of ECHO HOA professional service providers. Join me today in thanking our sponsors. Our premier sponsor is the Heritage Bank of Commerce. The Q&A sponsor, Silver Creek Association Management. The registration sponsor is Levy, Erlinger and Company, LLP, CPAs. And now we'll have a few words from Lionel Soto of the Heritage Bank of Commerce. Lionel?
Thank you so much, David. It is my pleasure and our pleasure with Heritage Bank of Commerce to be the premier sponsor of today's presentation. Heritage Bank of Commerce is a regional bank located in California. We have several specialty niches, one of them being HOA banking. So we have a full one-stop shop for all your needs, including operating and reserve accounts, sweep accounts for insurance, information reporting, checks and statements, remote deposit capture, downloadable transactions, stop payments, ACH. We also have loans for your SB 326 projects. We have certificates of deposits. And one of our most popular products today, with all the turmoil in banking, if you have large deposits, we have CD placement service. So ask me how I can help you with your association's funds, and we will share best practices with you. Again, looking forward to this presentation from Stephen and Diana. Thank you so much for being here today.
Great words there, Linnell. Linnell and Heritage Bank is our association bank as well, so we really appreciate the service that they provide us. And actually, Heritage Bank of Commerce will be speaking later this month about loans and other banking issues. So stay tuned for that, a little more on that later. Please support all of our ECHO professional service members and especially our sponsors here today. They make our educational programming possible at little or no cost to you. And now on to today's presentation. Deanna Liebert prides herself on being a hard worker with attention to quality and reliability. She thrives on orderliness and is committed to helping clients through complicated election processes. Her goal is to help managers and board members and the communities they serve have fair and lawful election processes. Deanna began her career as a certified paralegal and began working at various real estate law firms in 2011. She has worked in the homeowner association industry since 2014. Deanna is also a notary public. Our second speaker today is Stephen M. White, Esquire. He is a founder of the law firm White & McDonald, LLP. Mr. White has developed diverse real estate and construction practice. Mr. White serves as general counsel to community associations offering services associated with document interpretation and enforcement, member discipline, fiduciary responsibilities, document amendments, and election matters. Beginning on August 1st, longtime partner at White & McDonald, LLP, Rob McDonald, will be retiring. Mr. White will be continuing the practice under its new name, White Law Group, Inc. Congratulations for that. I think that'll be an exciting time for you, and we will miss your partner in our business. So why don't we go ahead and start the program? Deanna, please take it away.
All right, hello everybody. So this presentation about elections is a hot topic. We are getting into election season, so it's very relevant. Elections have become long, complicated, and expensive. I'll be honest with you guys. It's best practice to have a professional inspector handle the election process, but for standard general elections and when money is tight, the inspector can delegate some of their duties back to the association. Our goal is to show you how to get an election going, navigate the complicated statutes, governing document provisions, and legal requirements, help you build proper form templates, and give you best practice advice to avoid common challenges. There are 3 decisions to be made before starting any election. The first is whether or not you want a balloted election or if you want to try for acclamation and opt into acclamation. You have to decide who the inspector will be and how involved you want the inspector to be. Steve will then discuss association governing documents and election rules and individual election parameters. And then I'll take the floor back. We'll go back to basics and go over the most commonly used forms, form requirements, and best practices. Lastly, Steve will cover the dreaded election challenges. So next slide, please. All right, so we've all seen this before, the election calendars for balloted versus acclamation. We've been hearing the presentations on this, for the last 3 years. So just generally, the first decision you need to make when starting an election is whether you want acclamation or balloted. I have here in front of you the balloted election calendar. It's a traditional election calendar. It's a 4-month process. Before you decide if you want an election by acclamation or balloted, there are a few things to consider, such as how large is the association. Larger associations, of course, have larger mailing costs. Are you anticipating a contested election? Is quorum an issue? Have you had an election in the last 3 years? Are there any time constraints? All these factors go into making a decision if you want balloted versus acclamation. The balloted election calendar, the traditional calendar, is a 30-30-30-30 timeline. You send the call for candidates with a 30-day deadline. Then you send the pre-ballot notice 30 days after the nomination deadline. And the ballots go out 30 days after the pre-ballot notice. The ballots are out for 30 days, and then you can hold your meeting to count votes. Pretty straightforward timeline that we've all become very familiar with. One important thing to note is that you can switch from acclamation to balloted election, but not from a balloted to an acclamation election. So that's why it's important to make the decision from the very beginning. In the next slide, you have the election by acclamation calendar. There are two different types of calendar for acclamation. The first is uncontested, and then the second would be a contested election, meaning there are more candidates or than positions available. For the uncontested election, sorry, 1 second.
And Deanna, while you're looking at that,
Yeah.
This is a good opportunity for me to highlight the main point you made at the beginning is a key one, and that is, your communities, you board members, whether you're going to have more candidates than there are going to be available spots on the board. Make a decision early about whether acclamation is going to be even an alternative. If it is, you need to jump on things much sooner than you would with a contested election. It should be easier, but in fact, it's actually harder in terms of the timing. So take the blood pressure of your community early and find out how many candidates you're actually going to have for the board before you begin the process.
Yeah, excellent point. This acclamation process could take between 3 and 6 months. So for the uncontested election, it could be a 3-month process. You do have to make sure, as I mentioned before, full elections are held every 3 years, and that means quorum is being met at those elections. We're going to start the process off with a call for candidates. That's going to have a 90-day deadline. Then you're going to be sending the second reminder notice 30 to 7 days before the nomination deadline. And at the nomination deadline, you'll then be able to determine whether or not you have a contested election. If you do have a contested election, you can go to the next slide. You're going to be going through the entire acclamation nomination process for 90 days and then switch to the balloted process. And that takes about 6 months. The second decision the association must make is who the inspector will be. Next slide, please. Technically, this does not need to be done until after the nomination process, but it is best practice to decide at the beginning so the division of labor is clear. The inspectors may be appointed by the board, the membership, or just any other method. Inspectors may be a member of the association, a notary public, a CPA, or volunteer poll worker with the county. They cannot be a board member, a candidate, related to a candidate or board members, or currently in contract with the association, such as the association's management, legal counsel, or CPA.
True.
If you choose a member of the association to be the inspector, make sure they are covered by the association's insurance policy and that they are, in fact, reliable.
Yes, and it used to be the case that attorneys could serve as the inspector of elections, but because they're ordinarily under contract to provide other advice to the association, that is no longer permissible.
All right, next slide.
All right, if you're going to have a contested election or things are going to get heated in your community as they are in relationship to special assessments, recall elections, sometimes rewrites and amendments to the governing documents can create some animosity in a community. If you're going to have any sort of trouble in relationship to this particular election, I strongly urge you to hire a professional inspector of elections. I know I have to say that because Deanna is a professional inspector of elections, but honestly, having dealt with multiple challenges to elections in hindsight, having a professional inspector makes a world of difference in resolving those types of disputes down the road. If you've got a member who may be embroiled in the actual dispute, it makes it a nightmare. So if your election is going to be contested in any way, shape, or form, or you think there's going to be quite a bit of opposition mounted for whatever is being balloted, I strongly encourage you to hire a professional inspector. Pays for it, easily. All right, that's my public service announcement for you, Deanna. Sorry.
Thanks. All right, next slide. This one's pretty complicated. It kind of reminds me of the meme where there are the three Spider-Mans that are all pointing at each other and look the same. So we have the
right over my head, Deanna. Go ahead.
Sorry. So we have the inspector, management, and nomination committee. All three have distinct roles, but many of those roles may overlap. The inspector duties that cannot be shared are performing acts that may be proper to conduct the election with fairness to all members, determining the authenticity, validity, and effect of proxies, designating a location for returned ballots, determining when polls close, verifying member information and signatures on the outer envelopes, receive ballots from members and open and tabulate those ballots, determine the results of the election and report the results to the board, hear and determine challenges and questions, and keep custody of election materials, oversee recounts, make records available for legal challenges and inspection. The roles that management has, or the associations has that cannot be shared, are determining the voting power of each member, which should all be equal unless the declarant still owns lots. Provide a voter list, which is essentially a membership list. I wouldn't have access to that. Determine whether or not a candidate is qualified. Also, an inspector does not have access to documents such as deeds, account balances, etc. Also, it is the association's responsibility to engage in an internal dispute resolution with disqualified candidates. An inspector can kind of oversee that process, but really shouldn't be involved. That's between the candidate and the association. Nominating committees are kind of just solicit candidates. The inspector and management can also do that, but that's really the primary goal for the nominating committee. There are a list of shared tasks that should be kind of assigned before the election really gets started to avoid confusion and kind of too many hands in the cookie jar situation. That is the first, creating a timelining, setting reminders just to keep the ball rolling with the nomination. Once you get started, you don't really want to lose momentum. Managing the nomination process, who is sending the nomination form and who is collecting the forms. Preparing a voter list and candidate list. We'll go over these more. They're kind of internal documents. The candidate list should be prepared by the person who is receiving the nomination forms. Drafting and mailing election materials such as notices and ballots, and mailing ballots with the election rolls and replacement ballots as well. This is a lot to be responsible for. I have heard some say that there's a minimum of 3 1/3 hours per 100 ballots if you're just receiving and tabulating them. I always think it's a little bit more. But it's just, you know, there's a lot to be considered. So once the type of election, the inspector, and the individual duties are decided, we must examine the governing documents and election rules. And I'll turn that over to Steve.
All right. There are inevitably some conflicts between these documents. You've got your governing documents, principally your bylaws, which are going to control an election. There are portions of the Civil Code now that are heavily content based on elections. And then there are provisions of the nonprofit mutual benefit corporation law that's in the corporation code that govern elections. And then this newly fashioned election rules, which everybody has been required to have for the last few years. And often there may be conflicts amongst those various documents. When there are conflicts, there is within the Davis-Sterling Act a couple of hints that help us try and resolve those conflicts. One is found in Civil Code section 5100 B as in boy, E as in elephant. my writing's not great, which says that in the event that there's a conflict between the nonprofit mutual benefit law, namely that in the Corporations Code and the Davis-Sterling Act, the Davis-Sterling Act is going to control. There are other provisions within the Davis-Sterling Act, Civil Code Section 4205, that one I can read a little bit better on my notes, that resolves conflicts in favor of articles, CC&Rs, bylaws, and operating rules. And that's the hierarchy of documents. Election rules are operating rules. However, election rules are also mandated by the Davis-Sterling Act. So if you arrive at a conflict between these various documents and they can't be resolved by the authorities that I just provided for you, namely Civil Code Sections 5100 and 4205, get advice from an attorney regarding which one is controlling, because it may very well influence how your election is to proceed and what are the various avenues by which people can submit things such as proxies, powers of attorney. Those types of things arise during the course of an election that can often be the result of conflicts between the governing documents, which may be somewhat antiquated, and what the Davis-Sterling Act now provides. All right, next slide, folks. Okay, we've also got quite a few concepts that are associated with an election that you should have a better understanding of, particularly if you are going to be that volunteer member inspector of elections. The first of which I'm going to talk about is going to be at the top of our little chart here, and that's proxies. Only another member of the association may serve as a proxy. And what is a proxy? A proxy is a written document that delegates the authority to vote on behalf of a member to another member. Again, it must be another member. How that person votes is not part of the proxy. It may be on a separate piece of paper. It may be something orally provided to the other member, but it is not part of the proxy that you as inspector of election should accept. If somebody has a proxy for another member and that other member that signed the proxy shows up at the meeting, that proxy is no longer effective. There's another provision within the Davis-Sterling Act that allows non-members to vote in the rare occasion that they have a general power of attorney to vote on behalf of a member. It is a very rare circumstance, but it is a nuance in the election rules that it now allows somebody who is not a member for the first time to vote for a member if they have a general power of attorney. Nominating committee, I'm working backwards, counterclockwise on this chart, is something about which Deanna was just speaking a moment ago. With the new election rules and the opportunity for everybody to nominate themselves or another in the community, another member that is, the need for nomination committees is rather obsolete. Nevertheless, many of the bylaws that you'll see drafted include provisions for nominating committees. You may see the language may, in other words, the board may appoint a nominating committee, or the language shall appoint a nominating committee. If it's the latter, appoint a nominating committee, and let's use those people to essentially knock on doors and solicit interest in serving on the board. I think more often than not, in our communities, we have people that are somewhat apathetic, and if you can get more people involved in the process, all the better. Look at the various notice requirements. Notice requirements for nominations are just something that Deanna just covered for us. That's all specified and dictated by statute. So notwithstanding what's in the governing documents, for the most part, you're going to be covering notices for nominations as it's dictated by the code. Floor nominations. This is something that you see in older documents, in other words, nominations at the floor, but this is also during a period of time when the election was actually held at an annual meeting and people raised their hands and said, I'm voting for Leonel, I'm voting for David. Those elections are no longer permitted for director elections. So if your governing documents provide for nominations from the floor and you want to engage in that process, you're going to have to set a separate meeting at which nominations from the floor can actually be solicited from members, because once the ballots are prepared, nominations from the floor are moot, because nobody's going to be able to deliver a nomination because there is no floor. You only have this written ballot. Write-ins. Write-ins are also made somewhat obsolete, but we still see them in governing documents. you can write in a candidate on the ballot, but nobody else is going to know about that candidate unless you started knocking on everybody's door beforehand. And if other members don't know about the possibility to write in that particular candidate, then it makes for a complicated election and one that's likely to be contested. I would encourage all the boards out there to adopt election rules which make any sort of opportunity for write-ins moot. In other words, do not allow it, because it just makes the process that much more difficult. Quorum and reduced quorum, that's going to be specified by your bylaws. Quorum is going to be identified in the bylaws, and then if you don't get sufficient ballots by the end date, you may move to a reduced quorum figure. It's ordinarily a percentage of the membership. And then the last topic is cumulative voting. Cumulative voting is dictated by the Corporations Code. So that's the nonprofit mutual benefit corporation law about which I was speaking earlier. That is going to be trumped by the Davis-Sterling Act. But nevertheless, ordinarily in bylaws, you'll see reference to the fact that cumulative voting is only operative when somebody advises that they plan to accumulate their votes in advance of the election. And if the board has not received advice from a member that they're planning to accumulate their votes, and that provision is in their bylaws, before the ballots are disseminated, then cumulative voting is no longer going to be permitted because nobody has given notice of it. And that's important for the inspector of elections or the counsel for the association who's preparing that ballot. Cumulative voting instructions are a little bit more complicated than more conventional voting. And it's important that they be explicitly stated in the ballot so people know exactly how it is they're to cast their votes. So if a member has not articulated their preference to accumulate their votes in advance of the election, the ballot's going to reflect more conventional voting standards and cumulative voting will not be permitted. And there is a possibility that some ballots may be invalidated because somebody decided on their own that they were going to try and accumulate their votes when the instructions provided a more conventional style of voting. So those are those topics. Next slide.
All right, so next we're going to dive into the forms. I take over elections mid-process sometimes, or just at the end, just to receive and tabulate votes. And I commonly see a lot of mistakes on forms. So I think if you're trying to manage your own election process, I think that I wanted to use today to go over form requirements, the legal requirements, and the best practices. All of the orange line items indicate that the same forms are being used for each type of election: the balloted election, uncontested acclamation election, and contested acclamation election. Each type of election needs an appointment form, a call for candidates, voter list, candidate list, and notice of tabulated results of the election. Then there are forms specific to the type of election, such as the reminder notice, the notice of receipt of nomination and qualification, pre-ballot notice, the ballot, and a notice to continue. You can see by the number of bullets in the balloted and uncontested acclamation column that there's just as much work, just as many forms. And of course, contested acclamation election is far more complex. Next slide, please. To get the process going, once you've selected an inspector, there should be an inspector of election appointment form. It's not necessarily a form, it just needs to be, but it can be, it's just an appointment of the inspector. It should be reflected in the minutes.
And if I could just interject there for Deanna, that form is significant because it's going to allocate the various responsibilities of the inspector of elections as opposed to the management office, because to some extent you'll see it is common for the management to participate in some way, shape, or form in an election. They're going to have to obviously provide a voter list to the inspector of elections. There are going to be other tasks that the management company is going to have data to that the inspector is going to need. So it's important that this appointment reflect who is going to take care of what during the course of the election. Sorry to interrupt you there, Deanna.
Correct. Yeah. The name of the inspector, what their duties are, the return ballot address, all best practice. You could also have the inspector sign the form certifying that they are independent third party and that no conflicts exist. Next slide, please.
And it's a good idea for whenever you do make that appointment of the inspector of elections, that be reflected in the written minutes of that meeting. So there's no confusion about that task later down. I've had challenges where some people have contended that the person who actually served as the inspector of elections was not given that authority in a meeting, and there's no minutes to reflect that. So it's important that you document that.
Next, we have the call for candidate form and candidate nomination form. There are two different types of these forms, one for a balloted election, one for election by acclamation. They're similar, but have a few differences, which I will point out. The call for candidate notice is different depending on whether the association is opting in or out of acclamation. The legal requirements for the call for candidate form for a balloted election are the instructions on how to nominate someone. A member can become a candidate for the election to the board by submitting a candidate nomination form for his or her candidacy, which is self-nomination. Third-party nomination is also allowed but not encouraged. The form must list the qualifications to be a director. All candidates must meet the following qualifications. They must be members of the association. There may be term limits that may also apply. There are optional disqualifications in the association's election rules, such as being delinquent in regular and special assessments, joint ownership of board members, owner being a member of the association for less than 1 year, and a criminal conviction that would prevent the association from getting insurance. Lastly, the form must also include the nomination deadline. The nomination period for a balloted election must be 30 days, 90 days if opting into acclamation. It's also recommended that this form include a request for a director election statement. A director election statement must be reasonably related to the election. I think it's best practice to have this statement due at the same time as the nomination form. A receipt from the nomination form is also important. Include a statement that is each person's responsibility to confirm with the person collecting nomination forms that it was received. The number of board position available, this is just for general information. It is a legal requirement, though, on the acclamation call for candidate form. And then the candidate confirmation, a place for the candidate to sign the nomination form to confirm that the candidate meets all the qualifications.
And Deanna, if I could interject, one of these things that you spoke about a minute ago was the candidate statement. I'm seeing more and more conflict arise regarding conflict statements or candidate statements. Some candidates will like to provide 250 words about why their association is so messed up and all the things that they can do to help it, some of which is surprisingly factually flawed. I'm not a big proponent of candidate statements because people use them more as a platform to discuss why it is that the association's messed up as opposed to why they are the best candidate to serve on the board. But one thing that boards should all be aware of is when you get one of those 250-word descriptions of why your association's so messed up, the association's board cannot redact any of that material that's in it. It must send it all and say that these are the words of the candidate himself or herself and do not reflect any of the opinions of the board or other members of the association. I find that generally speaking, those long diatribes of why your association's so messed up generally hurt that candidate, but if they want to put themselves in that position, I just want the boards to be aware of the fact that they can't redact any of that information, even though it may be completely irrelevant to their qualifications to serve on the board. Sorry to interrupt you there, Deanna.
No, that's all good point. All right, so the next slide. This is legal requirements for the acclamation call for candidates form. It's mostly the same as the balloted election. However, there are additional requirements. The first is a heads up statement. You have to put on the call for candidate form that if at the close of the time period for making nominations, there are the same number or fewer qualified candidates as there are board positions to be filled, then the board of directors may, after voting to do so, seat the qualified candidates by acclamation without balloting. There is, of course, a 90-day deadline on the call for candidate form, unlike the 30-day deadline for the balloted. The number of board positions this time have to be on the form. It's not optional. It's also important to note that individual delivery is required for all acclamation notices, not general delivery like for a balloted election. Next slide. If you are trying to elect directors by acclamation, you send the call for candidate notice, and then about 60 days later, 7 to 30 days before the nomination deadline, a reminder call for candidate notice must be sent via individual delivery. It has all the same legal requirements as acclamation call for candidate form, but you must add the list of qualified candidates as of the date of the notice. So as you're receiving candidates, you're putting them on the candidate list. Those candidates have to be announced on the reminder notice. I like to send this notice in like about 20 to 30 days before the nomination deadline, because just the more notice, the better. It's also can be emailed, like an email blast to remind people to that the nomination period is open. And next slide. We have the voter list next. This is mostly internal document. The legal requirement is to include the member's name, the member's address at the association, the mailing address if different, and the voting power of each member. The voting power should be the same if the declarant is no longer owning units. It needs to be made available to membership. It does not need to be published to the entire membership, and members are only entitled to check their own information. Next slide. The candidate list is also mostly internal. The legal requirement is to include the candidate's name and candidate's address at the association. It needs to be made available to membership. It does not need to be published to the entire membership. Names will eventually be listed on the pre-ballot notice though, and of course in the reminder notice if the election is by acclamation. The candidates are only entitled to check their own information on the list. For record keeping purposes, I also like to track when the nomination was received and when it was confirmed by sending the notice of nomination or notice of receipt of form and qualification, and whether or not a director election statement was also received. It's just a lot to keep track of. Just to have it all in one place is kind of smart. Next slide, please. The notice of receipt of nomination qualification. This isn't so much as a form as it can be just a simple email or letter to a candidate saying, I received your nomination, you're qualified and you will be added to the candidate list. Or if they're unqualified, the reason, and to offer IDR. This must be sent within 7 business days of receiving a nomination. It's only a requirement for acclamation, but is also best practices for balloted elections. Both notices can be sent together if it is a self-nomination.
And I encourage board members to please verify candidates before the ballot is prepared. Often enough, management will believe that a particular person is interested in serving on the board as a candidate, but they really don't want to be a candidate in that instance. And we've had to retract ballots and restart the nomination and voting period as a result. It's very expensive.
Steve, I think David just asked to explain IDR. Do you want to take that question?
So IDR is an acronym, obviously. It stands for Internal Dispute Resolution. IDR is relatively informal. It's a couple of members of the board of directors. It may include the management company. It doesn't have to. And more recently, legislation was changed to allow for lawyers to participate. And you can imagine how productive the process must be as a result of that change. But bottom line is it's an informal opportunity for each side to express their grievances and concerns. And if the parties can come to an agreement that is consistent with the law, consistent with the governing documents, and consistent with the authority that the board has, If both parties sign a written agreement following an IDR session, that is enforceable in court as by way of judgment. So IDR is a means by which to informally resolve disputes. It's going to be difficult in this instance for IDR to actually produce a productive result in relationship to somebody that does not qualify as a candidate. IDR has to be offered to any member who does not qualify as a candidate, and Dan has gone through the various reasons why they may not qualify. One of which, is, of course, is not being a member. Going to IDR is not appropriate with somebody who is not a member of the association. Only members of the association are entitled to IDR. So we're not going to see terribly productive results from that process. But somebody that perhaps is in arrears in their assessments, who wants to come to some sort of a payment plan, and that may be a basis for them to serve as a candidate for the board, that could be a productive resolution. Somebody who's been convicted of a felony and will not qualify under a bond, because all directors are ultimately going to have to qualify under a bond. That may be a problem that the association can't come to some sort of a resolution about. But nevertheless, if you're going to disqualify a candidate, you must offer them internal dispute resolution, and that can be conducted, within a matter of hours or days after the notice is given. And the parties should try and have a good faith discussion regarding the obstacles to that particular candidate serving on the board.
All right, thank you. Next slide, please. All right, the pre-ballot notice for a balloted election. Pre-ballot notices are required for director and recall elections. They are optional for assessments and amendments. You must pick the inspector before sending the pre-ballot notice because it contains a lot of the inspector's information on this notice. The pre-ballot notice must include the ballot deadline and return information, the date, time, physical address to mail or hand deliver the ballots to the inspector of election. Must include the meeting information, the date, time, and location of the meeting at which ballots are to be counted, which is usually the annual meeting or some type of special meeting, and the candidate names who will appear on the ballot. It is best practice to also include the election rules website on there. If you have it already, you just put it on there. And also the notice of voter list. Notice of voter list is a statement saying a voter list has been prepared. If you'd like to update your mailing address, please contact the undersigned or the association management inspector, whoever is managing the voter list. I recommend that you add the notice of voter list to just your annual packet materials and just do a kind of catch-all statement yearly in those materials. It could also be on the pre-ballot notice. It kind of doesn't make sense to have a notice of voter list, because if you're sending a notice of voter list to a member's mailing address, they're not going to get it. So it's kind of, it has its obstacles. Next slide, please. All right, so now we're going to jump into the ballot materials. This is the most common area for mistakes. Ballot package must include the ballot, the election rules, ballot instructions, and secret ballot envelopes. You may also include a cover letter, candidate statements, notice of meeting and agenda, approval of the previous year's minutes, and adoption of the IRS resolution. If you're sending out secret or written ballot, you might as well include those additional materials at little to no cost extra. Next slide, please. We have the ballot first. The ballot must include the purpose of the election, the candidate names. I like to list them in alphabetical order by last name, number of directors to be elected and their terms, whether or not cumulative voting or write-ins are allowed, the ballot deadline, which has to be the same as the pre-ballot notice, and the quorum requirements. Most commonly, I see the quorum requirements are left off the ballot. So always remember to include that. I also like to include 3 additional statements. A statement that the balloting period may be extended if the required number of ballots have not been received to establish quorum. A statement that only members of the association are entitled to vote, and a statement that the ballot is irrevocable once turned into the inspector. Legal counsel should always prepare the ballots for commonly challenged elections, such as assessments, amendments, and recalls. Like Steve mentioned in his earlier slide, if there's big financial implications or commonly challenged, issues, just have legal counsel prepare the ballot.
Yeah, and I just answered a question in the Q&A regarding how many times a board can extend the balloting period, because often we won't meet quorum with respect to the return ballots, and we know that it's a waste to conduct the meeting. Often enough, the ballot should reflect the fact that the board can extend the balloting period. The ballot should reflect how many times that can occur and for what period of time. So, for example, and often my ballots will say, hey, the board reserves the right to extend the balloting period for 2 sessions of 30 days. And then notice of the fact that they're going to extend that balloting period should be delivered well before the deadline occurs. So if the first deadline for ballots is, I'm going to use September 1 as a magic date, before September 1, the association should provide notice to everybody that they're going to extend the balloting period for an additional 30 days. And then at the end of that, if they want to extend it for another 30 and they reserve that right under the ballot, they can do so.
All right, thank you. Next slide for the ballots. You must include the election rules. Election rules must be enclosed with the ballot materials. It can be a full enclosure or on a website. If it is a website, there's very specific language that must be used in 12-point font. The ballot must say specifically the rules governing this election must be found here, and then provide the link. I like to have that website password protected so that not just anybody can access it. I prefer the website method because some election rules I see are 20 pages long, and that's a really big mailing expense that I like to avoid. Next slide, please. Next, you have the ballot instructions. The legal requirements for this are to simply describe the secret written ballot procedures, such as no signatures, name, or addresses on the completed ballots, how to use double envelope instructions, instructions for the outer envelopes, ballot return address, and deadline. I think it's really helpful to include a picture in the process for returning the ballot. You see the blue ballot goes into the blue envelope, which goes into that return envelope. That picture has saved me from a lot of confusion. Next slide, please.
Pictures are always good.
Yes, and color coding. So the secret ballot procedures, and you must enclose 2 envelopes with the ballot materials. The return ballot envelope, which is the white envelope you see in the image there, and then the secret ballot envelope, the blue one. You could use whatever color you like. I just use blue. The delivery envelope is what you're delivering the ballot package materials to members in. I like to put ballot materials are enclosed, please vote, in big bold letters regarding your property at such and such association, so that people do not discard it because it looks like spam or something like that. The return ballot envelope, in order to be tabulated, the return ballot envelope must include the owner's name, address of the association, and signature. Without those 3 things, again, the ballot cannot count for quorum or be tabulated. I think it's best practice to pre-print the owner's name and address on the outer envelopes and then highlight the area for the owner to sign so that there's 0 confusion. We want as many votes as possible to be counted. The return postage should also be included since the election is being conducted by pretty much exclusively by mail. Secret ballot envelope is what members put the actual ballots into. And again, color coding is important with pictures. That's important too. Next slide, please. And now you have all the additional materials. If you're sending the ballots, you might as well include the following materials. The cover letter, it should be informative, not telling people how to vote, just general information about the election. Notice of meeting and agenda. Previous year's minutes can be approved by the board or a membership. And the IRS resolution, it can be approved by membership only. But secret written ballot is not required, but if you're sending out a ballot, you might as well just include it on there.
And two additional points on this. You recall what I said about candidate statements. I know people like to submit candidate statements, and maybe you can have a prescribed form that asks maybe some very narrow questions so we don't get that 250-page diatribe about how your association is so messed up. But the other thing that needs to be enclosed with a ballot, if it's the subject of the election, is any amendment. So if you're doing a restatement of your governing documents, or you're doing an amendment to your bylaws, as many communities are now, to extend the terms of directors so we don't have to have these expensive and complicated elections every year, that has to be enclosed with the actual ballot.
Correct, yes. Next slide, please. Now we have the notice to continue meeting and ballot deadline. Sometimes you may not make quorum. If that happens, you may need a notice to continue the meeting and ballot deadline. If an adjourned meeting is announced at the original meeting, this notice is usually not needed. It is only needed if the ballot deadline also needs to be extended. This notice must contain the new ballot deadline and return information, the new meeting information, and it must be sent via general notice before the current deadline expires, as Steve previously spoke to. It is best practice to email blasts to all owners for sooner delivery. I do not extend the ballot deadlines if reduced quorum has been met, because then you don't need to send a notice. So I don't know what your thoughts are on that, Steve, but you're kind of just.
Sorry, I was muted.
Oh.
Yeah, my comments are consistent with yours.
Yeah. Right, and finally, the notice of tabulated results of the election. At the conclusion of the election, the inspector should provide a report to the board that can be sent to members via general notice. It simply certifies of the results of the election, it gives the tallies, and it is signed by the inspector. The tabulated results of the election must be promptly reported to the board, recorded in the minutes of the next meeting, made available for review by the membership, and reported to the membership within 15 days via general notice. Those are all the forms that you will come across in the election process. It was a lot. Next slide.
All right, this is the fun stuff. So let's let's fight about that election that we just spent thousands of dollars to conduct. So who can challenge the election? Only a member can challenge the election, because only members have the right to vote. Recall what we talked about earlier. In the rare case that somebody has a general power of attorney to exercise the voting rights of a member, independent of that, it's going to be a member, either voting on behalf of themselves or by another member by way of proxy. The statute is Civil Code Section 5145. It's within the Davis-Sterling Act that speaks to election challenges. And it prescribes a year deadline from the date that the inspector notified the board and the membership of the election results. So there is or was a 9-month period in the nonprofit mutual benefit corporation law for a period of time. That is obviously superseded or trumped by the Davis-Sterling Act for the reasons I communicated earlier. So the deadline by which to present an election challenge is ordinarily 1 year. Where can you bring challenges? You can bring challenges in small claims court or in superior court. They will be heard in either one. What is significant about choosing one of those venues is the IDR and ADR requirements, because alternative dispute resolution is not warranted in a circumstance where the claim is being brought in small claims court. As some of you may be aware, before an association or a member can bring an enforcement action, and that means essentially that we're going to bring a lawsuit regarding violation of either the governing documents or the Davis-Sterling Act, you're supposed to go through a couple of hoops. The first hoop is IDR. If a member requests that the association engage in IDR, the association cannot refuse. So the association should sit down in that process I was describing earlier, a couple of board members, maybe management company and the disgruntled member or members, and they try and iron out their differences, and hopefully lawyers stay out of it and something gets done. The other is alternative dispute resolution, or ADR. And an association or member cannot file a lawsuit in superior court without first requesting alternative dispute resolution. What's the distinction between alternative dispute resolution and internal dispute resolution? Really one person, a neutral, somebody who is unbiased. It can be a retired judge. It can be a retired attorney. It can be an active attorney. They don't have to be retired. And that individual will sit and try and effectively mediate a resolution between the parties. If you're going straight to small claims court, where you can get injunctive and declaratory relief, and I'll explain those in a moment, you can dispense with the requirement for ADR. Injunctive and declaratory relief are going to be orders to do or not do things, or a declaratory relief action may result in a ruling that somebody has misinterpreted the documents and X should have been done or Y should not have been done. Those are the types of rulings that courts ordinarily prescribe strictly in superior court, but in relationship to small claims challenges to elections, that type of relief can be provided in a small claims court. What do you need to demonstrate in order to successfully challenge an election? Really not very much. If you can demonstrate that any of the procedures about which Deanna has spoken about today and are codified in the Davis-Sterling Act, or your election rules or governing documents were violated, then you have delivered what we call a prima facie case and have satisfied your burden of proof in relationship to an election challenge. There's a caveat to that. If the association can demonstrate that, notwithstanding the technical violation of either the governing documents, election rules, or Davis-Sterling Act, the results of the election would be no different, then you as a challenger loses. So the initial burden is on a challenger to demonstrate that there's been a violation. That is proven by what we call preponderance of evidence. Preponderance evidence is just weighted, 50.001% in favor of you. And so if you can demonstrate that to the satisfaction of a trier of fact, a small claims court judge or a superior court judge, then you have met your initial burden of proof. But at that juncture, the burden of proof shifts to the association to demonstrate that if the outcome of the election would be no different, notwithstanding the violation, then the challenge actually loses. So what's a factual circumstance in which that can happen? Well, I'm going to speak to something that's been articulated in some of the questions today that I've been trying to answer while Deanna's been talking so much more over me. I apologize, Deanna. But it could be a circumstance where the management company was accepting the ballots in lieu of the inspector of elections. Well, technically, it's Civil Code Section 5110, C3, an inspector of elections is supposed to receive the ballots. What does that mean? Well, often for most associations, the ballots will actually be delivered to the management company and then delivered to the inspector of elections. That's not truly a receive. A receive means that the ballots are actually delivered to the inspector of elections. But if in opening those ballots, 99% of the folks voted in a particular manner, then that particular violation would not be sufficient to change the outcome of the election. And in that instance, the challenger would likely lose. So consider those factors if you're going to challenge an election. There are various remedies that the courts can offer a successful challenger. If you're a member of the association and you're challenging an election, you can actually get a $500 fine for each violation. Now, that doesn't mean if a ballot's messed up and it's written incorrectly, every member that received that ballot, you get $500 for every one of those folks. No, it's just a single violation of $500. If you consulted an attorney, notwithstanding the fact that you're in small claims court where attorney's fees are not recoverable, if you consulted an attorney in advance of the small claims hearing or in advance of filing your action, you may recover those attorney's fees. Generally speaking, and I'm not entirely clear why, associations that are involved in these challenges generally do not recover their costs unless they can demonstrate that the challenge was frivolous. And I'll tell you that most of the challenges I see to elections are frivolous. But I'll end it on that. I see David's appeared, and I think we're at the end of our materials anyway. So thank you, everybody.
Wonderful. That was a wonderful presentation. We're going into our Q&A session right now, which is sponsored by the Heritage Bank of Commerce and Silver Creek Association Management. I want to say thank you to Deanna and to Steve. Great presentation. Now, I'd like to ask that our participants go to the Q&A section and vote for your favorite questions, because we have a lot of questions in there with about 20 minutes to cover those. We have 56 questions so far, so please do that. I will also let you know that if you go to that feature and you look in the upper right-hand corner, you probably can see a button that says, or a couple of words, most recent. And then if you click on that, you'll see most upvotes. That, especially for our speakers today, that will tell you which questions have been asked the most times and are voted for the most times. So click on the most upvotes. And so we'll give them a couple seconds to do that. I want to thank you again for covering so many of these questions, especially during the program. Much appreciated for that. Let's go ahead and, as soon as you're ready, Steve and Deanna, take a look at the first question. It looks like it's winning by 1 vote, and that's by the anonymous attendee. It's a long question, so go ahead and take that one, deal with it piece by piece, and do what you can. Some of those questions you may have already answered because this was written quite a while ago. So when you feel comfortable.
Yeah, okay. I mean, so to this question, there's a myriad of problems here. Is we have no election rules, which you're required to have at the time of your election. There was apparently no voter list, which is another requirement. And they moved the signature to the back of the envelope. I don't find that necessarily a violation. Deanna, is there something erroneous about putting a signature on the back of the envelope so long as there's identifying?
Not that I know of. It's just best practice to put it on the front.
Yeah, and
it's just then the return mailing address is right there, so the post office would be able to return it to the proper person.
Yeah. So what's the overall question here? I compared ballot envelopes against title company report and found 28 that could not be validated. And
it kind of sounds like a very specific question to the individual association.
I'm surprised so many people joined this question because it's such a unique set of facts. Nevertheless, my suggestion would be to pay attention to the 1-year deadline by which challenges to elections need to be brought. And consider bringing a challenge if you think that the election was not conducted properly. You know, a little bit for the old Esquires out there, I encourage you to talk to an attorney as well. But this seems very fact specific. And I think all of the topics that Deanna and I have covered today have helped you at least give you some background by which you should consider your options.
The last question there, is court the only option for them, or you mentioned ADR and IDR?
Well, we talked about IDR and ADR. If a member initiates IDR, the association's obligated to participate. So and those are far more cost-effective resolutions than going to court. So I would encourage a member that thinks that they can succeed in convincing some members of the board to reconsider the results of an election to engage in either IDR or ADR or both if necessary.
Okay, so let's bounce on up to G. Williams' question. Is there one source to find samples for best practice forms?
No.
Yeah.
I mean, I have my set of forms that were prepared by, attorneys, and I use those and customize them for each election. Each election has those individual election parameters that are so specific to their individual association, it'd be hard to find samples and best practice forms tailored to your individual associations. So there are a lot of resource guides out there. Of course, this presentation has all the legal requirements that you need. Unfortunately, I don't think there are any like cookie cutter forms.
Yeah, I think Connor wanted to answer part of this. So Connor, go ahead and take it away.
Yeah, so for this, since everything is very specific and unique to your association, it's having the forms available isn't the easiest, but we will have this PowerPoint and we can send this out to all the participants, and then you can go through all the forms. They're listed down there in slides. I think it's like 16 through 30 or so. You can actually go through the requirements of every form and where they need to be located. And that'll probably be the best, at least cookie cutter method that we are able to provide today.
So how long will it take to get the slides sent out?
So the slides were actually sent prior to this meeting. So if you registered prior to this meeting, you should have a copy. And then if not, we'll have them sent out to you within 7 to 10 days of this event.
Perfect. Thank you, Connor. Okay, let's talk about what James has to ask. Yes, please define reduced quorum. What does that mean?
So good question. In your bylaws, there'll be a quorum, which is the number of votes or ballots that need to be received in order for there to be the basis for a meeting in which those can be opened and tabulated. And often enough, we'll get insufficient ballots returned just because there's strictly apathy in the community and nobody bothers. In that instance, your bylaws will often dictate a reduced quorum figure, which will be a percentage of the membership that's less than that ordinarily required. And there's a methodology specified in your bylaws by which you notice a new meeting at which you have a reduced quorum, and you can actually open and tabulate those ballots.
Okay, so here's an anonymous attendee asking, after our elections, the new members gather away from the meeting and vote for who will get each position. Is this legal?
The gathering away part is probably not legal. It is very customary when a new board is impaneled after an election for there to be an initial board meeting at which the directors will vote to put themselves, not the membership, just the board, votes to decide who will serve as president, the various offices, secretary, treasurer, what have you. That's common and often part of what's articulated in the bylaws as a requirement after they are impaneled or voted and elected. But doing that outside of an open meeting is not appropriate. So that should be done before the membership in an open meeting.
Okay, thank you. Stacy says, does failure to create a list meeting legal requirements and to make such available to membership or to the inspectors invalidate the election?
Well, the association is required to have a voter list, as Deanna communicated earlier, and every member has a right to review that voter list. The corollary to that is there is no affirmative obligation on behalf of the association to offer that opportunity to members. Members have to initiate that on their own. But getting to the meat of your question, which is the absence of a voter list the basis to invalidate an election? Think about what I said earlier. Would the outcome of the election be any different with a voter list? Probably not. So I don't know. A Weasley lawyer answer is, I don't know in this particular instance. but I suspect it's doubtful that it would change.
I don't know how you'd be able to conduct an election without a voter list, because a voter list is essentially a membership list. And in able to open and tabulate the ballots, you need to check the outer envelopes for the correct information. So I don't know how you would be able to conduct the election without having access to that information.
True, but
it must exist in some form.
Right, and I think that somebody will testify in a challenge that ballots were sent to every member. So the outcome of the election would be no different in that instance. A technical violation, you would meet your first burdens, so to speak. You'd establish a prima facie case that the election was not conducted properly, but the association would likely defeat you on the other end of it by demonstrating that no change in the outcome of the election has occurred as a result.
Okay, so the next question with 8 upvotes here is what happens if the management company is performing the inspector of elections job when a member has been selected as the inspector of elections? I presume that's done by a committee or the board. Don't know. My HOA only allows a member inspector of elections to count the ballots received. Seems like the management firm's jumping ahead and counting.
Yeah, nobody but the inspector of elections can open and tabulate or count. Tabulate's a fancy word they put in the Davis Sterling Act. The actual ballots. What I tried to answer this question for somebody else by typing a response, but I think what often the practice for some management companies is to physically receive the ballots. And I don't know what your stance is on that, Deanna, but receiving the ballots, as I articulated earlier under Civil Code Section 5110C3, is a duty for the exclusive purview of the inspector of elections. So if the management company is doing that, there is an argument that there has been a violation.
Yeah, I don't like it when anybody else receives the ballots but me. There are provisions that allow for third-party delivery of ballots, but that kind of it doesn't really pass the smell test of, it just doesn't really look good. It isn't really, it's not preferred. I mean, the management and inspector can share a lot of duties, which I discussed earlier, and there are a lot of overlap. There is a lot of overlap. The best practice would be to, in the minutes of, when the inspector is appointed, to explicitly detail the individual responsibilities so that there's transparency.
Okay, well, that's a good answer. Yeah, so we have less than best practices, and that's a less than best practice, okay? So Steve Rubin asked a really good question, I think, because we have a lot of self-managed members in ECHO, and you constantly said management company will supply, et cetera, et cetera. We have no management company. Do we need to specify secretary supplies, voter list, or someone else there?
Yeah, it's just whoever is the board. I guess I used the word management or the board. Management represents the board. So that was I could see the confusion there.
Mm-hmm. Okay, that's great. Yeah, and those duties can be spelled out in the bylaws, I'm assuming as well. Is that correct, Steve? Or
yeah, exactly. But generally speaking, this is not going to be something that this should be strictly in the election rules. I wouldn't expect to find it anywhere in the bylaws.
Okay. Okay, our HOA is not providing me with our specific election rules, even after requesting them twice in writing. After calling the management company, the property manager said all her buildings follow the Davis Sterling Act and emailed the Davis Sterling Act, not our election rules. So she emailed the Davis Sterling Act and didn't send the rules. This sounds like maybe a very specific case. I actually get calls on this all the time. So yeah, appreciate you taking a look at it and given us an answer.
They've got to supply the election rules. So if you're not getting the election rules, I mean, not only are they required to supply the election rules in response to requests for them, but you're also obligated to deliver the election rules along with the ballot, or have a link to a website at which the election rules can be seen. That's prescribed by the code. So you've got a successful basis upon which to challenge an election if you're not getting the election rules.
Thank you for that. Carol Clark, if ballots are not opened due to a lack of a quorum and the current board stays in place, what happens to the IRS resolution? And can you explain the IRS resolution?
Yeah. Okay, so the IRS resolution is something that has to be voted on by the membership. It can't be voted on by the board. And it is essentially what we call a rollover provision. In any given year, an association may have funds in excess of that which was budgeted. In other words, they didn't expend all of the funds that were forecast to be expended over the course of the year. And in lieu of getting taxed on those funds, the membership has to vote to roll those over into the following year's budget, so that there's no actual income earned by the association because it's a nonprofit mutual benefit corporation. So the IRS resolution is an opportunity for the membership to effectively say, we don't want to be taxed. We're agreeing to allow those funds to be transferred into the new year's budget and used for the purposes that we ordinarily expend funds.
And the answer to the question, what happens if they don't get a quorum and with the IRS resolution, does it?
Then you need to talk to a tax attorney. The IRS resolution should be passed by the membership. That much I know. The ramifications of which in not getting that resolution adopted on an annual basis is something for somebody in the tax field to answer.
Yeah, you might need to specifically ask about the membership and have a membership vote on the IRS resolution. That seems like a logical solution.
Yes, only the membership can vote on the IRS resolution.
Yeah, so you might have to just have a vote or a voting of an election of whether they're going to elect that rule or not, and get away from the rest of that. Carol Clark also asks, can we limit the length of the candidate statements, number of words?
Yes. Yes, you can impose a limit. Will somebody follow that? Maybe not. And if they don't, can you redact any portion of it? No.
Okay. Does it have to be a reasonable length?
Yeah,
So is a reasonable the standard you'd use?
Yeah, I mean, 50 words or less tell us how you're the, greatest thing we've ever met. Okay. For the most part, yeah, I think I kind of like candidate statements that have more definitive questions, like list volunteer tasks that you've undertaken with the community in the last 10 years, and keep it very limited, and that avoids the kind of diatribe that we see sometimes.
Okay, can a candidate statement include endorsements of other candidates?
That's a tricky question. It depends on whose candidate statement that is, and whether they're speaking with if they're a director, whether they're speaking with their board hat on. The board cannot endorse any particular candidate. It also can encourage people not to vote for any particular candidate. So if a director is running and wants to endorse another candidate, how is a member to know that that director candidate isn't wearing their board hat when they're doing that? It's a slippery slope. So my recommendation would be to avoid endorsement of other candidates.
Okay. What issues, reasons would disqualify a candidate?
We actually went through those during the course of this presentation, and they're spelled out. 5115, Deanna, do you remember? Oh, it's actually 50 Civil Code Section 5105. And there are also some alternatives in that Civil Code section that associations can adopt in their election rules. In other words, they're not required by code to be the basis for disqualification, and that those are if I recall correctly, whether somebody's been a member for a certain period of time, for example, a year within the association, whether a member is current in the payment of their assessments. Those are optional bases upon which candidates can be disqualified, and those are spelled out in the code.
The joint ownership and criminal conviction as well.
Yeah, and we've covered those today.
Yeah.
Okay, and Rick Covey says, well, how are you going to know that it's a felony conviction unless you do a background check?
Well, as I said earlier, that particular director is going to have to qualify for a fidelity bond, and they will do that type of background check. Parenthetically, I'll point out that I actually had a director that was elected that was convicted of a felony and was still able to secure a bond. So apparently it wasn't that bad a felony.
Okay. So Rick Thorpe is asking, he's not quite clear about the distinction between acclamation and balloted as a descriptor.
Well, balloted means that everybody's going to get a ballot and are going to vote for the candidates, and the candidates that receive the most votes are going to be elected to the board of directors. Acclamation applies only when the number of candidates is equal to or less than the number of available seats on the board in that given year. And as Deanna was describing earlier, there are a myriad of notice requirements that have to be met in order to satisfy an election by acclamation. But assuming all of those have been met, the board can then vote to seat themselves principally, because they're the ones that are going to be elected by acclamation, back into office because the number of candidates are equal to or less than the number of available seats. And so long as the notice requirements have been met and the number of candidates is the same or less than the number of seats to be reserved, acclamation can be employed.
Okay, sounds good. So I think we're at the 2:22 point right now, and I wanted to stop the questions right now, and we'll go ahead and close out the meeting. But before I do that, I want to just say once again, thank you to Deanna Liebert and to Stephen White. You did a wonderful job. We appreciate your support here today. And thank you to all of our, to the people that attended today, especially our members. I want to thank our members for coming today and supporting our ongoing ECHO webinars. And for those of you today that are here today that aren't members, we invite you to become members and to join ECHO. Just go to echo-ca.org and click on the membership tab, and you'll find a form to fill out and send to us. For ECHO members, thank you for supporting us, and please invite your friends, boards, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes to encourage a person to become an ECHO member. Please help us grow the ECHO and continue our excellence in HOA education. I think one thing a lot of folks don't know about ECHO is that we are primarily funded by HOA communities. And so that's something we cherish and we really appreciate. And it means we act as your advocates. So please encourage your communities to join. If you would like to become more involved with ECHO, we have a few opportunities for you. These are presented on the slide that Connor put up right now. If you have anything that looks interesting, that if you see anything that looks interesting, please drop me an email and I'd be happy to respond. Now, for our other announcements, our East Bay Resource Panel and TCAR, the ECHO Club at Rossmore Rossmore, will meet in person on July 26th from 9:30 a.m. to 11:30 p.m. At the Fairway Room at the Creekside Clubhouse in Rossmore. We will be discussing finding, selecting, and managing your community management company. So if you're in the process and want to know how to take a look at community management firms, that will be available at that meeting. We will be discussing that. And if you're not a Rossmore resident, don't worry, just come in and tell the gate guard. You have to register. They'll know who you are. The next ECHO Board Members Club meeting is August 8th. It meets via Zoom every second Tuesday of the month from 5:30 to 7 p.m. The topic of the next meeting discussion will be interview questions and RFPs for management firms. I think a theme is here, right? The Board Members Club meeting is open only to ECHO members who serve or have served on an HOA board, and they must be ECHO members. These highly interactive peer-to-peer learning forums are scheduled from 5:30 to 7 p.m. and are available via Zoom. Please contact Connor at echo-ca.org to learn more about the Board Members Clubs and how you can participate. Once again, thank you to our sponsors for making this workshop possible. Thank you, Deanna and Steve and Stephen, for your developing and presenting the materials. And of course, thanks to all of you for attending today and making this a successful event. ECHO appreciates your investment in education to foster a better quality of life in HOA communities.